We continue to read the Libel and Slander Act, and we are at section 9, costs. In the case of any indictment or information by a private prosecutor for the publication of any defamatory libel, if judgment shall be given for the defendant, he shall be entitled to recover from the prosecutor the costs sustained by the said defendant by reason of such indictment or information. So they seem to be saying that the person who was libeled or slandered can recover legal costs, money spent on attorneys. Right, to continue. And upon a special plea for justification to such indictment or information, if the issue be found for the prosecution, he shall be entitled to recover from the defendant the cost sustained by the prosecutor by reason of such plea, such costs so to be recovered by the defendant or prosecutor respectively. Let me see that again. If the issue be found for the prosecution, he shall be entitled to recover from the defendant. So the person who was defending themselves, from libel and slander, shall recover the costs sustained by the prosecutor by reason of such plea, such costs so to be recovered by the defendant or prosecutor respectively. Okay, so if somebody sues you for libel and slander and you win the case, then whatever money, they seem to be saying whatever money you spent, you can sue that person to recover the legal costs, your legal costs. Of course, if you take somebody to court and you win, if you take somebody to court for libel and slander and you win, then you can recover your court cost. Or if somebody takes you to court for libel and slander and you actually win, the court judgment is in your favor, then you can recover your legal costs from them. Alright, we continue. Recovered by the defendant or prosecutor respectively, to be taxed by the proper officer of the court before which the said indictment or information is tried. How costs to be recovered? Alright. Section 10. In all cases where a general verdict of guilty or not guilty shall be returned by the jury on the trial of any indictment or information to which a plea or justification has been filed under the provisions of this part, the costs, when taxed by the proper officer, shall be paid and payable by the private prosecutor or defendant, as the case may be, to the other party, and may be enforced by the attachment under the seal of the court, or by a writ of fere factias, if I pronounce that right, issued in the form now used for the enforcement of judgment. This term here, I'm looking online to see the meaning of it. F-I-E-R-I, F-A-C-I-A-S. What I found this in Wikipedia. F-I-E-R-I, look like fiery fascia, usually abbreviated FI. FA. It's Latin for that you cause to be made. That you cause to be made. Okay. It is a writ of execution after judgment obtained in a legal action for debt or damages for the sheriff to levy on goods of the judgment debtor. Now, as for writ of execution, it's also known as an execution. It's a court order granted to put in force a judgment or possession obtained by a plaintiff from a court. Right? So, writ of execution obtained after judgment. All right. So this is, let's see what this says again. May be enforced by attachment under the seal of a court or by a writ of fascia. My pronunciation, issued in the form now used for enforcement of judgment. Right. Part 11. Newspaper defined. In this part of the Act, newspaper shall mean any paper containing public news, intelligence, or occurrences, or any remarks or observation thereon, printed for sale and published in Jamaica periodically, or in parts or numbers at intervals not exceeding 26 days between the publication of any two, periodically, or in parts or numbers at intervals not exceeding 26 days between the publication of any two such papers, parts, or numbers. So it's if it is published once a month, that would exceed 26 days. Anyway, Section 12. No criminal proceeding for libel without fiat of the Director of Public Prosecution. No criminal proceedings shall be commenced against any proprietor, publisher, editor, or any person responsible for the publication of a newspaper for any libel published therein without the fiat of the Director of Public Prosecutions being first had and obtained. Now this word, the fiat of the public prosecutor, or the fiat of the Director of Public Prosecution. Looking online, the legal definition of fiat, what I see is here it's a legal authoritative decision that has absolute sanction. It's from the Latin, let it be done. The word fiat is a binding edict issued by a person in command. Alright, so no criminal proceedings shall be commenced against any proprietor, publisher, editor, or any person responsible for the publication of a newspaper for any libel published therein without the fiat of the Director of Public Prosecution being first had and obtained. So if you want to sue the newspaper itself in which the publication was made, you have to have the consent. It has to be agreed by the Director of Public Prosecution. You have to get the go-ahead from the Director of Public Prosecution to do so. All right. A resident magistrate Section 13, hearing before resident magistrate. A resident magistrate, upon hearing of a charge against a prosecutor, publisher, or editor, or any person responsible for the publication of a newspaper for a libel published therein, may receive evidence as to the publication being for the public benefit, and as to the matters charged in the libel being true, and as to the report being fair and accurate, and published without malice, and as to any matter which under this or any other enactment or otherwise might be given in evidence by way of defense by the person charged in the trial and indictment. So it seems as if this is saying that defense, you're being sued for libel and slander, you might bring in certain things as defense. Your defense might be that the information was for the benefit of the public, or that you have evidence that the information is really true and is accurate, and you did not mean to cause any harm, right? And so on. Yeah. And the resident magistrate, if of opinion, after hearing such evidence, that there is a strong or probatable presumption that the jury on the trial would acquit the person charged, may dismiss the case. Right. Section 14. Duty of resident magistrate where libel of trivial character. If a resident magistrate, upon the hearing of a charge against a proprietor, publisher, editor, or any person responsible for the publication of a newspaper for a libel published therein, is of opinion that through the person charged is shown to have been guilty, the libel was of a trivial character, and that the offense may be adequately punished by virtue of the powers of this section, the resident magistrate shall cause the charge to be read to the person charged, and then address a question to him to the following effect: do you desire to be tried by a jury, or do you consent to the case being dealt with summarily? And if such person assents to the case being dealt with summarily mean immediately, the resident magistrate may summarily convict him and adjudge him to pay a fine not exceeding $100, and in default to be imprisoned for a period not exceeding 3 months. Alright, so if you are sued for libel and the court sees that the damages are really trivial, you have two options here. You pay $100 or spend 3 months in prison. That's what it says here. All right. Well, this is the latest document that I downloaded. Anyway, section 15, reports of judicial proceedings. A fair and accurate report in any newspaper of proceedings publicly heard before any court exercising judicial authority shall, if published contemporaneously with such proceedings, be privileged. With such proceedings be privileged, provided that nothing in this section shall authorize the publication of any seditious, blasphemous, or indecent matter. Alright, so if published, a fair and accurate report of any newspaper of proceedings published, heard before any court exercising judicial authority shall, if published contemporaneously with such proceedings, be privileged. Alright? Here, I look up the legal definition of privilege. I see it here. I see it on Wikipedia. In common law jurisdiction, a legal professional privilege protects all communication between a professional legal advisor and his or her clients from being disclosed without the permission of the client. The privilege is that of the client and not of the lawyer, right? So if the information, it seems as if the information is very embarrassing, the person might request that it not be made public. That seems to be the case here. Consolidation of actions. Section 16. Subsection 1. It shall be competent for a judge of the Supreme Court upon the application by or on behalf of two or more defendants in action in respect of to the same or subsequently the same libel brought by one and the same person, to make an order for the consolidation of such actions so that they shall be tried together. And after such order has been made, and before the trial of the said actions, the defendant in any new actions instituted in respect of the same or substantially the same libel shall also be entitled to be joined in a common action upon a joint application being made by such new defendants and the defendants in the actions already consolidated. In a consolidated action under this section, the jury shall assess the whole amount of the damages, if any, of one sum, but a separate verdict shall be taken for or against each defendant in the same way as if the actions consolidated had been tried separately, and if the jury shall have found a verdict against the defendant or defendants in more than one of the actions so consolidated, they shall proceed to appropriation the amount of damages which they shall have so found between and against the said last mentioned defendants and the judge at the trial, if he awards to the plaintiff the costs of the action shall thereupon make such order as it shall deem just for the apportionment of such costs between and against such defendants. Subsection 1 shall apply to the actions for slander and to actions for slander of title, slander of goods, or other malicious falsehoods, as it applies to actions for libel, and reference in that subsection to the same or substantially the same libel shall be construed accordingly. We will continue with section 17 in a different video.